Welcome to this presentation in which we're going to cover the first chapter of our textbook, and that chapter is entitled Prevention Philosophy. Here we are in the landing spot for our course Canvas website. So what we'll do is we will go down and click on the PowerPoint. So we're in Module 1, which again we see it says Prevention Philosophy Chapter 1, and then we'll go to this first item which says Chapter 1 Prevention Philosophy PowerPoint. Actually, when you pull this open, you'll see there's actually an item above here, which will be the lecture that you're listening to right now. But immediately below that lecture, you'll actually see the PowerPoint that we'll be using throughout this particular lecture. You have access to it, so you don't feel like you need to write anything down or add anything to the PowerPoint. Anything that you see on the PowerPoint you're going to have access to anyway, so don't feel like you need to, as you're taking notes during the lecture, that you need to write down what's on the PowerPoint because you already have access to that. Some students find it handy to go ahead and open up the PowerPoint, even to download it or to print it out, and then to use that as kind of the starting point for their own note-taking. That can be a useful tool if it makes sense to you. Awesome, wonderful. If it doesn't, equally good. Just be sure, of course, as always, to take careful notes. These lectures are going to be relatively short. They're certainly not going to be 3 hours a week for the most part, and so some students will benefit from watching the lectures more than once. Don't be shy. Don't feel like, oh my gosh, I must be doing something wrong because I didn't pick everything up the first time I heard it. As you know, online courses are supposed to be at the same level of rigor as face-to-face courses are. And so think about it. If you're doing all of the work that you do in a face-to-face class and yet you're not spending the 3 hours in lecture, what are you doing during those 3 hours you'd be spending in lecture learning the material? What's the additional 3 hours that you're doing? And some of that, of course, will be watching these lectures, but you'll also want to maybe reach out to me, come to my office hours, watch videos more than once, spend a little bit more time going through the textbook, maybe being a little bit more careful with your chapter outlines and all that good stuff. Anyway, let's get started. So we're going to talk about Chapter 1, which is entitled Prevention Philosophy. And that is the guiding concept that we'll see throughout this textbook. Let me begin by giving a bit of a testimonial, I guess, about the textbook. We are blessed with an especially good textbook. I have been teaching at Collin for 7 years, and I have probably taught, more than 10 classes here, and have dealt with many more than 10 textbooks. And this is one of my very favorite textbooks that I've had the privilege of working with. So we're fortunate to have one that is really, it really does a good job describing the law. It gets almost all aspects of the law correct. There'll be a few times that I'll say, hey, you know what, the textbook's not quite right here. But for the most part, it's going to do a good job in that area. And the main areas that I will be adding additional information to will be the Texas-specific answer. So there definitely will be stuff in our lecture that you'll be responsible for knowing that isn't available in the textbook, but the textbook does do a good job, especially as it is a national textbook, of covering most of the issues that you're going to be responsible for knowing on tests and quizzes and things like that. So the philosophy is, let's prevent a problem as opposed to solving a problem once it's here. And that makes sense. It's the same idea that you get when you are maybe studying to be a doctor or a nurse. You want to prevent the infection, not treat it once a person has it. Or you want to stop somebody from having a heart attack, so you prevent the problems that might be leading to that heart attack. That's a philosophy we have here too in hospitality law, and honestly that's part of hospitality management generally. Isn't it better to prevent the customer complaint than having to face the customer complaint? And of course we know that the best prevention philosophy, the most aggressive prevention approach, is not going to be 100% successful. You can bend over backwards and do everything that you can think of to make a customer happy, and sometimes you just can't. Maybe it's the customer who has unrealistic expectations, or maybe just circumstances conspire against you in a particular scenario. But whatever it is, no prevention strategy is going to be 100% successful, but it is the least expensive way of managing the risk, and it's the one that's going to result long-term in saving of money and saving of time and saving of frustration for everyone. So please take these to heart. They're going to, in the end, make your lives a lot smoother, a lot less stressful if you think about these approaches. Now, just like doing medically preventable things, sometimes they're not the most glamorous or the most fun things to do. For example, we probably all know we ought to eat fruits and vegetables, but you know what? The hamburger and the French fries look awfully good, right? And so sometimes we eat the bad food, even though we know that in the long run that may not be the best choice for us. And some of that is going to arise in the prevention area because yes, it saves time long term, it saves money long term, it saves frustration long term, but you're never sure what particular prevention act you take today that's going to save you heartache later on. And when you're in a rush or when you're stressed, it's tempting to say, well, I can cut this corner and probably everything will work out. Well, in a sense, you're right. I mean, many times people do cut corners and there's no negative repercussions. But when you start adopting that philosophy on a regular basis, you're going to find that you cut enough corners, there's going to be those problems, just as a matter of statistics. And those problems are going to be a lot more difficult to manage than if you had just taken that extra time and dotted every I and crossed every T. So this is a philosophical perspective. This is a way we approach these issues. Just like you want to drive carefully in a school zone, or you want to be sure to brush and floss your teeth every day. The same idea we see in managing hospitality risks. So we're going to look in this chapter about the role of the hospitality manager and how he or she interacts with the legal environment, and also about how we can prevent problems. How does the hospitality manager have an active role in preventing the development of legal problems? And finally, we'll talk about ethics. How do professional ethics play a role in avoiding legal risk? And we have several goals for this chapter. I'm not going to go through them in great detail, but we're going to first of all talk about why we need to know about the law in order to be successful in hospitality management. The goal of the course is, of course, not to make anyone in this class an attorney or a paralegal. We'll just be touching on a few issues. We definitely will not get into the weeds. We'll definitely not drill very far into these subjects at all. The main goal that we want to empower you to deal with are the things that non-legal professionals need to know in order to navigate in a legal environment, number one. And number two, when to get a legal professional involved. When is the right time to say, wait a second, I may be awesome at managing a hotel or managing a restaurant, but I'm not awesome at managing the law, and I need to get a specialist to help me with those types of issues. So doing the part that you can do as a non-legal professional, and then knowing when to pass off the matter to somebody who has special training. That's what we'll be talking about. We're also going to give a little bit of an overview about how our legal system works, just kind of an introduction to some concepts. You probably will have been exposed to many of these ideas in previous courses, so this may be a bit of a refresher into how our legal system works. Then again, we're going to talk about that prevention philosophy, that way of looking at legal problems within the lens of hospitality management. And then again, finally, the ethical issue. The hospitality industry is fraught with the potential for legal problems. Part of the reason it's fraught with it is that there's just so many different people involved. Think about in a hotel the different roles that people have. You have the people who maintain the building, the landscape keepers and the repair people. You have the people who keep the rooms tidy. You have the people who man the front desk, who serve drinks in the bar, who serve food in the restaurant, who hand out towels in the swimming pool area, who park cars in the parking garage. All of these people have different skill sets, different experiences, different levels of knowledge about how the law works and how is the most effective way to interact with other individuals. Then, so we have that class, we'll call that class our employee class. Then we also have our customer class, and they come with their own issues. Obviously, we can't train our customers to be the way we want them to do, but our customers can have things happen to them that they don't like, and that can result in some legal action. And they can also do things to our staff that our staff doesn't like, and that can create legal risk for us. So we have these two categories of folks who usually work together well, but sometimes don't, and we have to be prepared for that. And the unfortunate thing is we're never quite sure when that moment's going to happen, when that, waiter is going to have an issue with a restaurant patron, and see how those issues might play out. So we've got the human beings who work for us. We have the human beings who are coming to our facility to receive a service of some type. And then, of course, there can be problems with the actual real estate that we're on. What happens when there's an earthquake or a tornado? What happens when the elevator breaks down? What happens when somebody slips on some wet linoleum? All of those issues can have a role. And so there can be just lots and lots of different issues. And we haven't even gotten into things like, what if the food makes people sick? Or what if there is some kind of contractual dispute between, say, a vendor for the hotel at the restaurant and our business. So again, there's whenever you have individuals or interacting with each other, individuals interacting with kind of the physical environment, we have the potential to have problems. And those are just a reality in most industries, but especially in the hospitality industry. In fact, it's estimated in the textbook that 60 to 70% of all of the decisions you will make throughout the day, and you'll probably be making hundreds of decisions in a typical day, all of those decisions have the potential to create legal risk for you personally or for your organization. So when you decide to allow Bob and Larry to switch shifts, that has a legal implication. Or when you allow Teresa to come in late that particular day, that has a legal dimension. Or when you decide to promote Maria to that new position, that has legal implications. So when you think through all those decisions, it's easy to start thinking, oh, this is just one of these routine decisions I make all the time. And it is in some sense, but it has the potential to have legal consequences. And so it's always useful when you're making those decisions to pause and think, what could go wrong here? What are the stakeholders who might not agree with the decision I'm making? Or how could this decision play out in a way that's going to result in some kind of negative implication? It doesn't mean that you're still not going to take that action. It may still be the best action, but you want to at least pause and consider, how could this be interpreted in a different way? What's a different lens through which I can look at this situation? One of the most common areas that we see this legal dimension is going to be in the areas of employment law. And we'll actually have a significant amount of the course talking about employment law. Which is fortunate for me because that's my passion. I practiced law for 20 years before I came to work at Collin College, and the area that I practiced in was employment law. And so this is an area that I am especially interested in. And obviously I'm not going to teach a course in employment law here. That's because literally in law school I took 3 different courses in employment law. And so we will just be able to touch on these topics. But it's important to know a little bit about this area of the law. And I like to tell my clients when I was an employment attorney that almost as important as knowing a little bit about the law is also to know what you don't know about the law. And what I mean by that is, particularly the area of employment law, many people have a sense that they know how employment law works. But if you are a layperson, especially if you don't specialize in human resources, for example, it's probably the case that some of the things that you believe our legal system does with respect to employment law, some of those beliefs you have are very likely to be incorrect. And so if you are working in a paradigm that says, this is how our legal system works with respect to employment relationships, and yet your paradigm is wrong, well, you're setting yourself up for a world of hurt, right? Because you're going to make some assumptions based upon your imperfect understanding. And so part of the secret to learning about employment law is to stop and say, wait a second, I think this is how it works, but why do I think that? Am I right? Okay, maybe I am right. Let me confirm that I'm right about that. And if I can't confirm, let me be skeptical. Let me stop myself and say, wait a second, maybe that's right, and maybe it's not. And so be aware that some of the assumptions that most people have are incorrect about employment law. And we'll explore some of those in later chapters in this textbook, but I just want to flag that for you as an issue right now. So let's go to our next slide. So we're going to, let me get rid of that little circle there. See if I can do that. Clear. Okay, here we go. Well, it didn't clear, did it? Okay, well, we might, let me just try one more time. Annotate, clear, all dry. Oh, there we go, sorry about that. Okay, so we're gonna talk about a defined term. You'll see throughout the textbook that there are words in the margins of our textbook that are defined terms. And these are ones that are especially important that you commit to an understanding. A really helpful tool to work on learning definitions of terms is Quizlet. And I'm just going to stop here just for a second and go over and spend a little time on Quizlet. If you haven't used Quizlet before, I highly recommend that you consider using it. As you can see, it literally is the word quiz, then LET, period.com. And then I'm just going to log in. Not sure what my password is. I might get this wrong. Here we go. Let's see. Okay, here we go. We'll try another one. Okay, I will take that. I'm just going to do a search here. Okay, so let's do, this is for another course. This is my business law course that I teach. So I'm going to type that in. And you can see all the ones that say DC Groover, that's me. And so we'll go into, say, here's one. This is a student from one of my classes. And so what he's done is he's gone through and he's typed in lots of different words from the textbook. And so what he did was he took the word acceptance, for example, which is another word that you'll have in this course, and then he's given some definitional terms. Once you enter the data into Quizlet, and by the way, Quizlet is free. They will want you to pay for it, but no reason to go ahead and pay, in my opinion. What you can do is you can use flashcards if you want to, and so you can flip this. So let's say this is a flat part. If you're not sure what the answer is, you flip on these, say, it's acceptance. And you can go to the next one, and then again, you can fill this in. This is adhesion. Adhesion. So you can go through the cards. The flashcards can work, but they're not that fun. They're really not different than if you were to draw up your own flashcards. I think the better tools are the other ones. These provide a bit of a game aspect, and these provide a bit of a testing aspect. You don't ever have to worry about spelling in this class, so I wouldn't worry about this component. Probably the best way to prepare for tests, especially once you've developed at least a fair level of knowledge, is to go to the test function once you have all that data entered and choose multiple choice and true false. And it will generate its own test for you, and you can figure out what the answer is, and then it'll give you feedback. You know, let's say I picked, we'll say requires a creditor for that test number, question number 3. And so I'm going to check my answers. Oh, no, that's not the right answer. The right answer was writing. And so now I know that I need to work a little bit more on this concept. So it can be a really helpful way of learning the material. Now you may say, but gosh, Gruber, that's a lot of work to enter into all those terms. Well, please don't think of it in those terms, because actually entering the data is part of that learning experience. Having said that, in many of my classes, students will get together and maybe one student will take chapter 1, another student will take chapter 2, another student will take chapter 3, and so on. There's a total of 15 chapters in this textbook. So one way would be for everyone to take one chapter and maybe have some duplication of chapters, and then give everyone access to your particular Quizlet chapter, and then everyone can play these games and do all these things to get familiar with the terms. Again, that's completely your decision, but I do encourage you to at least consider this approach. Now I'm going to go back to our chapter, and we're going to talk about this first term. We have the term attorney. So what is an attorney? Well, I'm sure we all kind of have a sense as to what an attorney is, but an attorney is a specialized term. It has a very specific meaning. Imagine for a second that you weren't feeling very well one day and you decided to go and Google doctors in McKinney. You live in McKinney. And so you Google the term doctors in McKinney. You're looking for a doctor. You didn't like your last doctor, so you're between doctors. Anyway, you see an ad pop up for Dr. Cynthia Groover. She's a general practitioner. And so you call up, and guess what? She has an opening this very afternoon. So you hop on down to my office, and I examine you, and I say, you've got blah, 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 itis disease. And what you need to do is you need to go and get in your bathtub with exactly 100 ice cubes and fill the water up and sit in that bathtub for 4 hours. And you will be healed if you do this. And so you're like, oh, that's weird, but hey, Groover's a doctor, so I'm going to do what she says. And in fact, that doesn't heal you at all. It just makes you sicker because now you're miserably cold on top of not feeling well. And you discover after you go see another doctor, because my treatment didn't work, the doctor's like, that was bad advice. You shouldn't have done that at all. Let's research this Dr. Groover. And so the second doctor pulls up the medical records to see if I am in fact a doctor. And this doctor learns that, hey, there is no Cynthia Groover who's a licensed physician in the state of Texas. And so guess what I did? I engaged in the unauthorized practice of medicine. And that's a felony. And it ought to be a felony because when I, a layperson, or when you, a layperson, goes to see a doctor, we ought to be able to trust that person when he or she says, I have the credentials to treat your particular illness. And in fact, there are lots of cases out there of people who've pretended to be doctors, who've tried to treat people, and they have been prosecuted for not having the correct credentials. Well, we have this same idea in the law. If I call myself an attorney and I'm not, I have committed a felony. I have engaged in the unauthorized practice of law, which can be a felony as well. You could argue it's a little bit less serious for an attorney or for a person to misrepresent himself or herself as an attorney than for a person to misrepresent himself or herself as a doctor. And certainly, I think that's probably right because there aren't life and death issues involved. But still, a person's financial well-being is oftentimes at jeopardy when he or she is dealing with an attorney. Also, the welfare and access to one's children can be at an issue. So there are some important factors. One's liberty, if it's a criminal case, can be at issue. So if a person represents himself or herself as an attorney when in fact he or she is not, it's a very serious matter. Let's talk about what a person needs to do in order to be an attorney. Here we go. The first thing that he or she has to do is has to graduate from a four-year school, four-year college. It doesn't matter what he or she majors in, but he or she has to complete that four-year credentialing process. And then the next step is that he or she has to go to a 3-year law school. We are fortunate at Dallas-Fort Worth area that we have several different law schools. But an important function of a law school is that it has to be ABA accredited. The ABA is the American Bar Association, and it basically gives its seal of approval to law schools. And if a law school isn't ABA accredited, then that particular law student will not be able to sit for the Texas bar, not be able to practice law in Texas, even when he or she completes law school. So there would be no reason that you'd ever want to go to a non-ABA accredited law school. So once the individual graduates from college and completes law school at an ABA accredited law school, then he or she sits for the bar exam. The bar exam has several different parts, and it varies from state to state. One part is an ethics test, and another part is kind of a national test. And then finally, we have a Texas-specific part, which actually we have two parts in Texas. And so the candidate has to pass that part of the test. A fourth part is that the person has to pass a background test. This is looking at the person's character. Has the person committed crimes, had a problem with drug or alcohol abuse, or other perhaps ethical lapses, things along those lines that the bar will look into before the bar decides whether to allow this person to join. And then after a person has passed all these different tasks, then the person has the option to be sworn into the bar, and there are fees and responsibilities associated with membership in the bar. Fees, and we'll say obligations. As you can see, this takes a long time. I mean, there are people who have completed all 7 years of this schooling and don't pass the bar, or it takes them 2 or 3 times before they pass the bar. And there have been cases of people who have taken all of these steps, but then they weren't able to pass the background check. Well, guess what? If there's any of these steps that the person is unable to complete, then he or she is not an attorney, not licensed to practice in that particular state. So it's important to know if the person is an attorney. You might say as a layperson, well, how would I know whether the person that I'm going to see is eligible to practice law in a particular jurisdiction? Well, let me show you. To find out, you go to texasbar.com. This is the website for the Texas Bar Association. All attorneys who practice in Texas have to be members. Then we're going to go to the For Public. I think this is the one. Yeah, find an attorney. Here we go. And so we would type in so let's just type in Paul Elliott. So you can see if you're trying to find somebody, let's say we're looking for Paul R. Elliott, and we can find out, is this person a member of the Texas Bar? And yes, we can see he has a green light. He is eligible to practice in Texas. We can find out a variety of pieces of information about him, where he practices, when he was admitted to the practice, where he went to law school, things along those lines. But let's say I were to type in, we'll say Bob Smith Meyer Harris. Okay. My guess is we're going to find, wait, there is no Bob Smith Meyer Harris. And so therefore, if somebody says that's his name, and in fact, he isn't, he's not admitted to practice. Let's look at, oops, sorry, here we go. Daniel Morales. There are actually two Daniel Moraleses who have been licensed to practice in Texas, and one is in good standing. He's got a little green dot by his name, which means that there's no reason why he would not be a good choice to represent you. But you can see this other Daniel Morales has a little red box by his name, and he is not eligible to practice in Texas. You may recognize the name. Mr. Morales used to be the Texas Attorney General, and unfortunately he was convicted of a crime and therefore is no longer eligible to practice at this time. So when you see a red box by a person's name, that indicates that they are not eligible to practice law at this particular time. So it's important always to check the names of attorneys in this database before you make a decision about who to hire and how to use their services. Let's go back to our discussion. So hopefully that's provided a little bit more clarity about what we mean when we talk about attorneys. In a law office, you may find that in addition to working with attorneys, you'll also work with other legal professionals. And probably the most common category you're going to see here are going to be paralegals, or legal assistants, they're sometimes called. What is the distinction between an attorney and a paralegal? Well, an attorney is, by the way, before we go any farther, let me just say that most of the courses I teach at Collin are courses designed to equip students to become a paralegal. Obviously, since we're a community college, we aren't a law school, so we're not teaching people how to become an attorney. But many students, either because they aspire to be an attorney, choose to take paralegal courses to prepare them for law school, or some students decide that they want to become a paralegal, and so they take courses in our program to prepare them for that particular path. If the law ends up interesting you more than hospitality, you are welcome and encouraged to reach out to me, and I will be delighted to talk to you at great length about both the attorney career path and the paralegal career path. But let me just talk a little bit about what a paralegal is. The first thing to know about a paralegal is that a paralegal isn't licensed in Texas. A paralegal doesn't have to have a particular credential to practice as a paralegal in the state of Texas. And that's true really with some caveats in all states. So a paralegal can assist an attorney in providing legal services to a client, even though he or she doesn't have a particular educational or licensing credential. Having said that, the best compensated paralegals, usually the most successful and the individuals who have the most secure employment trajectory are going to be the individuals who have chosen to get certain credentials. Most paralegals choose to get their credentials through a community college situation like Collin College or many other community colleges. That can be a very good and smart path to becoming a paralegal. So again, if this area interests you, feel free to reach out to me. I'll be glad to talk to you in more detail about that. Another legal term that's important is litigation. It's probably one that you're very familiar with. We all know litigation happens when somebody sues somebody else, right? That's the act of beginning and carrying out a lawsuit. It can be a civil matter or it can be a criminal matter. We'll see most of the issues that we encounter in a hospitality law course are going to be civil matters. So what is the law? Well, like most really basic concepts, it's almost impossible to define because it's such a basic idea. You really can't break it down too much to more detail. It's kind of like, if you have an atom, how do you break up an atom into smaller components? Well, you really can't. But the law, as our textbook defines it, are the rules of conduct and responsibility that have been established by a particular society at a particular time. So the laws that we have today are different than the laws that we would have had 50 years ago or 100 years ago. And if somehow or another we were able to travel 100 years in the future, you can be confident that our laws would be somewhat different. Now, they're not probably going to be dramatically different. We're probably not going to legalize theft, for example. And certainly there would be similarities that we would see between the laws we have today and the laws that we had 100 years ago. But there would be important differences as well. For example, one thing that happens is that we have technological developments. 100 years ago, there really wasn't commercial air travel. There certainly wasn't the internet. And so there are important differences in how we interact and communicate with one another. And as a result, there's been a development of laws and standards in this area that would have been silly to have once upon a time. And then there are other differences that we see that may not be driven by technology. For example, back 100 years ago, divorce would have been a relatively unusual situation for a person to find himself in or herself in. And yet nowadays, divorce is a more common choice that one or both individuals make in a relationship. And so we have a much more robust legal system around divorce law, for example. So we see that when society changes, when the expectations that people have with respect to one another change, and it's constantly evolving, we see that the law usually uh, develops to reflect those particular changes. Because the law is changing, um, it's not unfortunate. I mean, it's a good thing because we want the law to evolve to reflect the needs of society that we have now. I mean, wouldn't it be a pretty crazy world if we were living with the laws that exist in the early 1900s? And so we wouldn't know what to do with the internet. We wouldn't know what to do with commercial airfare. I mean, air travel. We wouldn't know what to do with other social and cultural changes that have happened. And so we definitely need to evolve. But when you have a system that is changing, sometimes rapidly, sometimes slowly, you can't just learn it once and then be done with it. Okay, I know all there is to know about hospitality law. I'm beginning my career. We'll say I'm 25. I plan on being in this industry for another 40 years. I'll never have to think about learning any more hospitality law again. Well, that's not how it's going to work, because 40 years from now, there will be important differences in how we view some of these issues. And so what you know today will be a good stepping stone to that next iteration, the next iteration that we see. But you can't just assume, because that was true in 2017 or 2018 or 2019, that that's how it's going to be in 2049 or something along those lines. So keep in mind that the laws will evolve, they will change, and that you need to stay abreast of those issues going forward. And we've already talked about the preventative management style, so we'll go on from there. Let's talk about the idea of the common law. The common law is a bedrock concept that we have in our legal system. It's helpful, I think, to talk a little bit about some history of the United States, stuff that you're very well familiar with already, and that is, of course, that we began as a colony of Great Britain. And so when people from Great Britain came to the United States and established the 13 colonies, they were, for the most part, British citizens who had an understanding of British law. And so they brought that common law, that tradition that existed already in Great Britain, to the colonies. And for the most part, they didn't see a need to change. I mean, it had worked okay for people in Great Britain for hundreds of years, so people thought, let's just stay. You know, if it isn't broken, we don't need to fix it. And so they adopted the common law tradition that existed in Great Britain at that time. What do we mean when we say common law? How is that different than other systems? Well, generally, legal professionals think about there being two categories of systems for the law around the world. And one category is the common law. And that's a system that we have in the United States because, again, we were formerly a colony of Great Britain. It's also the system that you see in Great Britain and Ireland today. We see it in Canada, in India, and in other parts of the world that were formerly part of the British Empire. So we see it in some parts of Africa, some parts of Asia. We see that in the Caribbean, even parts of South America. We see common law traditions. And these traditions are based upon the idea that what a judge does when a judge is interpreting the law or adjudicating an issue, and he or she doesn't have a statute to look at always, the principle that he or she develops to decide the case, that becomes a precedent. That idea doesn't just resolve that issue for the particular litigants in front of that judge, but that nugget of truth, that timeless idea, can be used to solve the next case and the next case and the next case. And we call that idea, scroll ahead, stare decisis. The idea that one judge has to follow the decisions of higher judges within his or her court system. So if the Texas Supreme Court renders a decision saying XYZ, then if I'm a Collin County district judge, it doesn't matter whether I agree with the reasoning of the Texas Supreme Court or not. I have to follow that idea. That's that common law idea. That's that idea of precedent. That's the idea of stare decisis. And by the way, if you have an interest in Latin, let me just kind of show you how Latin works in this regard. Stare is a Latin word that means to stand. And decisis, as you can probably see in the word, means decision. So when we say stare decisis, what we're saying is that the judge has to stand on the decision that somebody else has made. And so that might be a little bit of a helpful way to think about this. It has nothing to do with staring. It's just a similarity between the Latin word and the English word. But think about stand, and you can see that there is a connection between the word stand and stare. So let's go back. Here we go. So we have the common law tradition, but what do other countries have? Well, when we think about continental Europe and most of Asia and most of Africa and most of Latin America, we find that there is a different system, and they have what is called a civil code system. Many of these countries, their civil code goes back to Napoleon Bonaparte. You may recall he was the Emperor of France in the early 1800s, and he was trying to expand his empire to include all of Europe. That was his ultimate goal, and in fact, he conquered a great portion of Europe. In fact, he went all the way over to Russia and conquered parts of Russia before he was ultimately unsuccessful. One of his goals, or one of his methods of conquering, was using a legal system to do so. You know, back in the day, back before there was this huge French Empire, people's legal systems were somewhat local. There might be a community who decides this is how we're going to solve this problem. But 3 communities over, they might have some different standards. Well, Napoleon said, look, the people in my kingdom speak different languages. They have different religions, usually a type of Christianity, but sometimes a type of Judaism or some other religious faith. And so, I'm not going to be able to persuade people to change their language or change their religion, but I can have a uniting presence in how the legal system works. And so that was one of his goals. So he had his legal scholars develop a very systematic, a very detailed civil code that was designed to answer as many questions as possible, so that the litigants no longer had to rely upon the judgment of the judges, but instead the judges just looked at the statute and says, okay, hey, you know what, the answer to your question is right here, and so I'm going to apply that answer to your particular situation. Now, in Great Britain, we didn't have this systematic, detailed code. In fact, there still isn't such a code in Great Britain, and there isn't such a code in the United States. We like to think in the United States sometimes that we've got lots and lots of laws, but really we don't. We really rely upon the common law to fill in most of those blanks. Most of our legal system isn't statutory. It's not what the legislature has done, though I don't mean to say they don't pass laws, but they haven't ever sat down. Our legislature, either on the state or national level, hasn't ever sat down and said, you know what, we don't really need the judges to develop law anymore. We're just going to be very systematic and answer all of our questions within our statute. We just haven't done that. It's not part of our legal tradition. Yes, we have statutes, and statutes take precedent over what the judges do, but the judges are doing probably most of the heavy lifting of deciding what is a contract, what is a tort, those types of basic legal issues. So that's the system that we have because of our connection historically with Great Britain. The civil code system is awesome and wonderful, and the common law system is awesome and wonderful. Our system, though, is the common law system. So I said that we had this system called the civil code system. That gets to be unfortunately confusing because we also have something called civil law. Civil code and civil law are not the same thing. When we talk about the civil code, we're talking about that systematic statute that is designed to answer as many questions about how you resolve disputes of whatever type as possible. But when we talk about civil law within the common law system, we're really thinking about it from a different perspective. We're comparing the civil law with criminal law. So yes, even though we're a common law jurisdiction, we do have civil law. Of course we do, because we've got laws about how you establish a contract. We have laws about what happens when there's a car accident, for example. We have laws about when you need to pay taxes and how much you have to pay. All of those things aren't criminal matters for the most part. They're civil matters. So don't get the idea of the civil code confused with civil law. You have civil matters within a common law jurisdiction. You have civil matters within a civil code jurisdiction. You have criminal matters within a common law jurisdiction, and you have criminal matters within a civil code jurisdiction. So it's a little bit confusing having those similar terms. We already talked about stare decisis, so let's go on. This is an example that the textbook kind of throws in a little bit randomly, and that is the Americans with Disabilities Act. This is kind of an example of a statute, because we've talked about the common law, we've talked about what the judges do, but of course, even though probably statutes aren't as important as what the judges do in our particular system, it's still the case that they're important. And so when we look at what statutes do, when we look at what the legislature does, one example of that is the Americans with Disabilities Act. And this is an important law for hospitality law managers. And so we have the idea that, and again, this is an example. We'll talk a lot more about this particular law later on. But the first thing that we notice is that it is a federal law. Okay, so we have in our system of law, we have two areas or two realms of authority. We have the state and the federal governments. And so we'll have laws that are federal laws and we'll have laws that are state laws. In this example, we're talking about a federal law. In other words, a law that has come to us from Washington, D.C. The Congress has passed a law. The president at the time, whomever he was, I think it might have been President Clinton, might have been the president when the Americans with Disabilities Act was passed. It might have been the first President Bush. I'm not quite sure about that. But anyway, one of those presidents signed a law and it went into effect. But we also have laws on a state basis too. And of course, while you're in the state of Texas, you have to be concerned about laws in both systems. So we have federal legislation that protects the rights of people with disabilities so that they can be treated fairly in the workplace. And, so this is one thing, be treated fairly in the workplace and have access to places of public accommodation such as hotels, restaurants, and airplanes. So as a hospitality manager, you're concerned about the statute in two different ways. You're concerned about it with respect to your employees and applicants to make sure that when you have an employee or an applicant with a disability, that you are complying with this law with respect to him or her. Then you also have to consider from the perspective of your customers, the person who comes to dine at your restaurant or stay in your hotel who might have a disability. What are your responsibilities with respect to him or her? So there's really two different areas to think about with respect to the Americans with Disabilities Act. And we'll talk about this in more detail. You'll see though, is when we talk about statutes, that there's oftentimes terms that you'll see and you may think to yourself, well, what does this term mean? I mean, what do we mean when we say disability? Do we mean somebody who is, for example, in a wheelchair, or somebody who is blind and has a seeing eye dog, for example? Those would be two examples of disabilities. But there are also other things that might not appear to be a disability at first glance. Perhaps it's an invisible disability, but that the law also protects. And so one of the things when you see a term like this that's really helpful to think about is, well, what does this term mean? please don't assume that you know what the term means, because it will be defined in the statute. And the way the legislature has defined the term might be broader than you had expected or narrower than what you expected. And so when you see terms like this, pause and figure out, okay, now I shouldn't guess what it means, I should figure out. For example, is somebody who is an insulin-dependent diabetic, is he disabled? He doesn't need a wheelchair. He doesn't need a cane. He doesn't need a hearing aid, but he does need insulin in order to remain healthy. You can't necessarily, though, look at him and know, he has type 1 diabetes. Or let's imagine somebody who has a learning difference, a learning disability. Perhaps this person has a dyslexia, or perhaps this person is autistic, or perhaps they have a disability, a mental health disability. Perhaps this person is schizophrenic or has depression or something along those lines. And so you'd want to find out a little bit more about what the term disability means to make sure that you are satisfying your legal obligations, both to employees and applicants, as well as to the general public. And we'll talk more about what those terms mean. It's not so important to know that right now, but more important to know how to approach those types of issues. Here we go. Sorry about this. Okay. So here's the definition of hospitality. We talked about what the law is. Let's just go back here and look for a second. The rules of conduct and responsibility established and enforced by a society. Now we're going to go down here and look at how we define hospitality law. Those laws which relate to the industry involved with the provision of food, lodging, travel, and entertainment services to its guests and clients. So you can see really from here on down, we're really defining the hospitality industry, more so than defining what law is. So you need to look at our definition from law and attach it to our definition for hospitality to make the most sense of this. So far we've talked about the common law. We've talked about our legal history, how we got this idea of stare decisis or precedent from Great Britain. It continues to be a very important and robust area of our law. We talked about civil law and how this establishes our responsibilities to each other outside of a criminal law context. But there are some important issues that can come up with respect to criminal law in the hospitality industry. For example, serving minors alcoholic beverages. Obviously, that's an important issue to be aware of as you are a hospitality manager in a restaurant or bar circumstance. Criminal law implications there. Or serving somebody, over-serving somebody, that person going out and might be in a car accident. There could be both civil and criminal consequences for your bartender or your wait staff, or perhaps even for the manager of the facility. We've also talked about how society changes, both technologically and culturally, and how that's going to cause the laws to change. And finally, we have the fact that we have both federal laws and state laws. There's also the category of local laws. These are oftentimes ordinances, and we're actually going to talk about these in many of our assignments. We'll have, you'll be looking up the ordinances for example, maybe Frisco or Allen or McKinney, to find out, well, what are the rules about serving alcohol, or what are the rules about smoking in public places under these particular guidelines. So we have really 3 levels. Now, it is true that local laws have to fit within the framework that the state has, because the local or the county or the city is a creature of state law. But the state isn't a creature of federal law. So you can have a federal statute and you can have a state statute, and they both are items that you have to comply with, because both of these branches or areas of government have their own sources of authority over individuals in their place. But local law is a creature of the power of the state government. Doesn't mean, though, that we don't have to follow it. Of course we do, but its power derives from the state. So it's really not a third area of of the law. So let's look at this preventative idea. We've kind of talked about at the beginning, and now we're going to go full circle and talk about it again. And this is the idea that we want to manage the risk of litigation. And the term that they have here is stem the tide of litigation. We want to reduce that tide. And unfortunately, many times you will find that people can be litigious. They want to, when they've had something unfortunate that they perceive of as unfortunate happen, many times the first response is, how can I get somebody else to take responsibility for this? How can I get money or some other benefits from that person or that entity? Sometimes it makes sense and is very appropriate. Sometimes you might not think it's so appropriate. Again, that's a value call that changes over time. The values of society evolve. But we're going to look at this idea of what you can do to prevent or at least to lessen the possibility of that happening. And we have a little acronym to work with, and that is the idea of STEM. So what is STEM? Well, it's a process that can be implemented that will reduce employee errors and omissions. And when we reduce employee errors and omissions, what happens? Well, we also reduce litigation, or at least we that's likely to be the outcome. So let's look at how we look at STEM. And as I said before, it's an acronym. We have select. We want to think about selecting the right people for the right jobs. We want to, once we've selected those individuals, we want to train those individuals so that they are very competent at their jobs, but also competent at the risks associated with those jobs. Then we want to educate ourselves to make sure that we know, number one, how to select and how to train these individuals. You may say, what's the difference between educate and train? Maybe not a big difference, but here we're thinking about how do we educate ourselves in these areas. And our need as a hospitality manager may be greater to get into the weeds about what the laws are. But when we're training people, they may not need to know the theory or all the details. They may just need to know, you can do this, you can't do this, it doesn't matter why, you just need to follow this particular rule. So many times this is a more cut and dried, a more bare bones approach. Sometimes giving too much information can actually make the training less effective. And then finally, perhaps the most important is managing. Because again, here we're managing mainly people, but we're also managing processes. And part of management is planning. How am I going to go about doing this? Maybe I need to hire a new employee. How am I going to select him or her? How am I going to train him or her? Then there may be the need to organize before we decide that we need to hire a new housekeeper, for example. We might want to stop and think, wait a second, maybe we can reorganize how we perform the housekeeping function. For example, perhaps currently we have a housekeeper clean each room. So she is responsible for vacuuming, dusting, fixing the beds, cleaning the bathrooms. But that you might decide, well, it might make more sense to have one housekeeper who's responsible just for vacuuming, another housekeeper who's responsible just for fixing the beds, a third housekeeper who's just responsible for cleaning the bathroom. So you might think maybe specialization might work better. And so you'd want to explore how to organize the work before you decide who to hire, because if you have specialization, then it might mean that you might not have to train all of your workers about the chemicals that you use in cleaning the bathrooms. Because if all I'm going to do as a housekeeper is make the beds, I don't need to know about the chemicals we use to clean the toilets and the sinks and the showers. And so there might be some savings that we can do. Of course, if you don't train everyone how to do that, and Sally, the bathroom cleaner, is taking the week off, and you have Bob, the vacuumer, subbing for Sally, well, you'll want to make sure that Bob is trained before he starts using those chemicals. We'd also want to control the flow of the work. Who's supervising? Who's making sure that Sally is using those chemicals appropriately and according to the instructions? Making sure that things are done safely for the customers, for Sally, for the other workers in the environment. And then finally, we have another M. So you might even think about this being the most important part of the manage, and that is to motivate. If you have a workforce and you select them well and you train them well, you're well educated as to what needs to happen, but you don't motivate them. You don't want you don't help them get to the point that they want to make the right choices, it's pretty difficult to be successful. It's pretty difficult to really reduce the risk of litigation. I mean, you can tell Sally all day not to mix those two chemicals together, but if you haven't persuaded her that that's in her interest to not mix those two chemicals together, there's a pretty decent chance that someday or another she's not going to be as careful as you would like her to be. And there might be bad fallout either for Sally individually, or for the guests staying in that hotel, or for Bob who vacuums, who comes in after Sally has combined those chemicals. So you want to motivate. There's lots of different ways you can motivate, but that goal of motivating the workers to complete the work in a way that is going to reduce that litigation. Let's consider another legal term that we have, which is the idea of liable or liability. And this term means that a person who is liable is legally responsible or obligated in a certain sense. So if I'm in a car accident with you, you're stopped at the red light, and I rear-end your car, well, guess what? I am liable. I am legally responsible for the damage to your car, and if you yourselves were injured, for the damage that you yourself experienced. Obviously, determining who is liable in a particular fact pattern can be a pretty involved process. But obviously, as a hospitality manager, you want to manage that, reduce that as much as possible. Okay, so now we're going to go through a little bit more on some of these terms. Let's go back here. So we're going to look at the term select in a bit more detail. As I say, we have whole chapters on this topic, so I'm not going to drill down too much into these ideas. But you're going to want to select the right employee for the right job that you have. So it's rare that you're going to have an employee who's perfect in every sense. If they are perfect in every sense, they're probably going to be too expensive for you to hire, right? And so you'll want to look at the whole bundle of things that make this person potentially the right person for the job. And the way to find that right person, of course, is going to take some time on your part. It's going to involve you thinking through, what skills does this person need to have? What is the right wage for me to offer this person? And what's the right way for me to find this person? What are the recruiting tools that I'll want to consider? And you'll want to apply those tools to all of the candidates that you're going to have to make sure that you are in fact getting the right or the most qualified person. Inevitably, you're going to need to interview. I mean, that's just the reality. And you'll want to think carefully about, what do I need to know about this person before I decide whether he or she is the right fit. This is a highly regulated area. There are lots of questions that are unlawful to ask. And sometimes those questions, it may not be obvious that those questions are unlawful, and it may not be obvious why they're unlawful. And so you need to, especially if you routinely are involved in hiring, you need to be very familiar with what you can and cannot ask. And if you want to get at a particular issue, how can you legally inquire about that? It's a little bit of a minefield, you could say. There's probably a way to safely navigate through the landmines, but if you're not careful, one's going to blow up. A common thing to look for is large gaps, and we'll have one in just a second. We'll see this in a second. And you want to be selective. You want to make sure that you are hiring the best person. Again, this takes a commitment of time and resources to finding that person. So when you're checking the applicant's background, you'll want to look for gaps. That's a big source of concern. Sometimes the most important part of a candidate's resume or application is what's missing. And sometimes it's easy to miss what's missing, because usually the applicant kind of wants you to miss what's missing, right? And so he or she may be working pretty hard at hiding or minimizing the importance of that issue. So part of your job is to be a bit of a detective and figure out what's there, and interpreting what is truly meant by what's there, and then also seeing what may not be there, and asking smart questions and doing due diligence to find out that stuff. In addition, you may need to look outside the four corners of the application and the resume. You may need to ask for things such as transcripts, uh, background checks, things along those lines to confirm the information that you are receiving and to confirm that this person is the best candidate for you. Again, this is a highly, highly regulated area. You should never ask for criminal background checks or any other kind of check without making sure that you are full compliance with the law. There can be stiff fines and other penalties associated with not dotting every I and crossing every T in this area. A common way to approach applicants is to give them tests. After all, you don't know just based upon what somebody says whether they're going to be good at the job or not. Let's say you're hiring somebody to cook omelets at your restaurant. Well, you know what? Someone might say they can cook a really great omelet, but you probably want to actually taste their omelet, right? You want to maybe see them make it. Um, See how quickly they can make it, see if they are doing it in a safe way, safe for themselves and safe for the customer. You want to see if it looks good, if it tastes good. All those pieces are coming together. And so it's reasonable to have tests, and there can be a variety of tests from written tests to actual uh, uh, job trial type tests. And so you want to think through what's the best way of approaching those issues. It is important that you comply with laws like the Americans with Disabilities Act, which we talked about earlier, but there are other laws that you need to also comply with. And of course, you always have to be careful that whatever you're doing, you aren't discriminating based upon race, color, which is a reference to skin tone, religion, age, and this applies to individuals over the age of 40, sex, and again, we're talking about you can't discriminate against women and you can't discriminate against men, national origin, and this could be somebody who is, well, we all have a national origin, obviously. Many of us have more than one place where our ancestors came from. So national origin can refer to where a person was born, if the person was born outside of the United States. It can also refer to where somebody's ancestors came from. Unless a person, of course, is Native American, we all have some ancestors from other parts of the world, which is awesome and wonderful, but some people may seek to discriminate against. That's unlawful, and you need to be aware that that is a protected category. And then, of course, we've already talked about the issue of disabilities. There are a few things that are bona fide occupational qualifications, but this is a rare exception, and we're not going to really talk about this yet. We'll talk about this in more detail later on. Training is such an important idea. It is, it's kind of an ounce of prevention is worth a pound of cure. If you train folks how to do something the correct way, once you're going to see that the dividends from that pay off every day that person is there. Effective training is going to result in fewer mistakes, less risk. So you want to train properly the first time, retrain when appropriate, reinforce training when necessary. One of the things that's important about training, in addition to the fact that it's going to reduce those errors, is that it creates a trail. You're going to have documentation to show, yes, we trained Sally about how to use those chemicals. And so let's say that despite your best efforts and your most aggressive training, Sally still makes a mistake. She combines those chemicals, she becomes ill as a result, and she files some kind of claim against the employer. Well, you'll be able to show, wait a second, Sally attended this training every year. It was 30 minutes of training. She passed this quiz that is offered at the end of the training. Each one of the 4 years that she went through this training, she knew that she couldn't combine this ingredient with this ingredient. And so when she did this, she was well aware of those risks. Having that paper trail, it doesn't have to be paper, it can be an electronic trail, but having that trail to show that the training has happened and ideally that there was some test that the student had to pass is really, really powerful from a litigation perspective. And you always want to be aware of what are the trends, what are the new laws in the area, what are juries and judges doing in these areas, what are the new regulations. It's going to put you in a better position to train your employees to anticipate future problems. I've already touched on the idea of the evidentiary trail. Who taught the course? Who was taught? Who was in attendance? What was taught? What was the agenda for the course? How was the training conducted? If it was a videotape, keep the videotape. If it was a lecture via PowerPoint, keep the PowerPoint. If there was some handout that students who attended the course received, keep that handout. Did you have a sign-in sheet? Was there a test that the employee had to pass afterwards? How did you determine its effectiveness? Again, that test can be a really powerful way of doing it, so it's a smart way of approaching that. And if you have a student that doesn't do well on the test, then put that student through retraining. The area of litigation is constantly evolving, but here are some common and increasingly common areas where we see litigation developing, especially in employment law context. First is negligent retention. Let's first of all look at the word negligent. To be negligent means to be careless, to not having put sufficient time and energy and thought into a particular action. So when you retain or keep an employee when it was probably more prudent to terminate that employee, you have engaged in negligent retention. So let's go back to our scenario. Sally's been trained several times on how to clean the bathrooms, and she knows not to combine these two chemicals. But you know what? She does it still. She does it pretty regularly. And so far, it hasn't caused anybody to get sick, not even Sally, but it's been dangerous. You've retrained her, but she keeps on having these problems. Well, guess what? Your decision to continue Sally in her current role could be a situation of negligent retention. Let's say that the next time Sally mixes these chemicals, it creates sufficiently toxic fumes that a small child who is staying in that room becomes very ill. Well, guess what? Her family or his family is going to sue, saying you should have fired Sally, or at least you should have moved Sally to a different job function when you saw that she was unable or unwilling to learn how to do this appropriately. So that's negligent retention. Another could be negligent supervision. Let's say that Sally, usually in most hotels, there is a housekeeping supervisor for every 10 housekeepers. And you happen to have 30 housekeepers in your a hotel, and so you'd ordinarily expect to have 3 supervisors. But you know what? It's hard to keep good supervisors, and you are down to only 1 supervisor. This supervisor is stretched very thin, and in fact, in addition to supervising the housekeepers, your supervisor also orders supplies, comes up with schedules, hires new housekeepers, and has a lot of other responsibilities beyond simply making sure that the rooms are vacuumed and the bathrooms are cleaned effectively. And so when Sally makes an error, it may not be because Sally is just unwilling to do it correctly, but she may not be supervised adequately. Or perhaps she hasn't been adequately trained in knowing how to clean the bathroom with the chemicals that are provided. So these can be areas of opportunity. Sometimes it's easy to think, well, I can save a little bit of money by not hiring that extra supervisor. Or I can save a little bit of money by not pulling all of my housekeepers into 30-minute training once a year on the chemicals. And in the short run, you may save a little bit of money, but in the long run, you may be exposing your employer to greater legal risk. So let's talk about the idea of motivation. I kind of touched on it a bit before, but let's do a little bit deeper dive. You want employees who feel a certain level of loyalty to the organization and hopefully to their supervisors and their managers. What are things that you can do? And first of all, let's talk about why. Why do you want that? Well, I mean, I guess it makes everybody happier and it's a positive thing just from the human aspects, but we're thinking about it really from a practical perspective. We want to reduce the risks of litigation. We're looking at this as a bottom line concern, not just being nice because we want to be nice, although that's not a bad thing, but being nice and positive and supportive of our workers so that we can reduce problems, which is going to save us time, money, and hassle later on. So one way to do that is to work at getting employees to feel pride and accomplishment and to feel good about the work that they're doing. If Sally feels pride that her bathrooms that she cleans are spick and span, and that customers are going to feel comfortable using the facilities. They're going to feel safe using the facilities. And she has a feeling of, you know what, I helped these people's vacation or their business trip be more successful because I was here doing a really awesome job getting this bathroom in good shape. When Sally feels that way, she's going to do a better job and she's going to make fewer mistakes. If she looks upon it as, oh my gosh, another toilet I have to clean, this is such an awful, awful job, probably she's not going to have nearly as positive experience. Probably the toilet isn't going to be as clean, and probably the customers aren't going to be as satisfied. You'd like to create a culture in which people feel that they are respected and that they are trusted. In the Christian religious tradition, we have a name for this, which is the Golden Rule. The way that this is often described is do unto others as you would have them do unto you. If you were Sally, how would you want to be treated? And applying that idea, even though you're Sally's supervisor, if you say, hey, if I were Sally, how would I want to be treated? Well, that's how I'm going to treat Sally. And guess what? When you treat your subordinates with respect, it usually results that they treat you with respect and that they appreciate that. It doesn't work 100% of the time. Nothing does, but it, in the long run, is going to pay dividends when you treat folks that way. It's also going to reduce turnover, which means you're going to have to spend less time hiring people, less time training people, less time dealing with the inevitable errors that the newcomer is going to make. You're going to enhance the experience that your customers have. They're going to be happier with the job that Sally is doing cleaning the bathroom. And you're going to reduce the risks of litigation and make the bottom line look better because you're going to have less of those problems. So as you're managing, you're going to want to lead by example. You're going to want to exhibit the characteristics that you want the Sallys and Bobs on your workforce to have. You want them to know, hey, you know what? I know how to clean the toilet too. And I've been through the training and I've taught the training and I am willing to get down there and get the scrub brush out and the toilet bowl cleaner and do that work. When Sally sees that the manager is familiar with what she needs to do and has done it, that goes a long way in motivating her to have a positive outlook. Another important thing is walking around. It's easy as a manager because you have so many responsibilities to be stuck in your office, sometimes behind a closed door dealing with things you have to. But it's easy maybe to make being present, being aware of what your subordinates are doing because you're seeing it a lesser importance. But that really isn't a lesser importance. Being present. When you walk by the front desk, how long is the line that the hotel guests have to wait in? How are these guests greeted by the individuals who are working the front desk clerks? Now, obviously, when you're there, they may approach the customers differently than when you're not, unless you can wear some kind of costume or whatever. My daughter likes to watch a show. And I can't remember what it's called, but Undercover Boss, I think. Anyway, in that show, a CEO from a fairly major company goes out to various work units, and he or she is not so familiar, not so recognizable that he or she can take on a different personality, different identity, and actually work in the facilities anonymously. Nobody knows that this is the big boss. And so that CEO oftentimes learns a lot about how things are really done, and sometimes learns how that some of the assumptions that he or she had about the business weren't true at all. You're probably not going to be able to be undercover boss, but you can, by being present regularly, you can get the respect of your workers and you can have a better understanding of what's going on in the workplace. It's so important to keep in mind that we live in a world of such diversity, and it is such a strength that we have in our country, where we have people from all kinds of different places, all types of different experiences, and we all can bring something to the table that is pretty darn special. But whenever you have cultural diversity, even though it's a tremendous benefit, there are the possibilities of having workplace tension because everybody comes from a different life experience. They have different preferences. They have different ways of communicating. Even things as straightforward as personal space. I was hearing a comedian the other day talk, and he was from a different part of the world where people don't have as don't have the same sense of personal space that most Americans have. And so he was waiting in a line when he had first come to the United States. And he was fluent in English, and he felt like he was fluent in the culture because, he was, again, very fluent in English, and he had watched American TV shows for a long time. So anyway, he was standing in line, and he noticed that there were these big gaps in the line, a foot or two between each person. And to him, that felt very inefficient. And so he would move closer to the person in front of him. And he was pleased to see when he did that, that would cause the person in front of him to move closer to the person in front of him and have this kind of domino effect. So the whole line moved up, and then he in the back of the line would move a little bit closer, and it would cause the line to get tighter each time. And so he was thinking, I'm helping this line be more efficient, be less of this dead space between. Anyway, one day he was in line with one of his friends who was a native-born American, and this dynamic was playing out, and the native-born American turned to him and said, "What are you doing? You don't need to be breathing down somebody's neck. You're making these people feel uncomfortable." Anyway, this person from a different culture hadn't even considered the possibility that he was entering the personal space of this other person, because that's a very culturally defined experience. Probably the people in line in front of this immigrant didn't even fully get why they were uncomfortable. They just kind of had this feeling of, what? I feel uncomfortable now. And so they probably wouldn't have been able to explain exactly why they moved a little bit farther. But it wasn't because they thought this was a great idea. They were experiencing some kind of social anxiety as a result. So there can be very subtle things that play a role in this. And there can be a lot more direct things. People who prefer to speak a different language, or prefer to dress in a different way, or people who have differing political views. Lots of things that can come out in the workplace that can result in creative tension. And managing through those things can be a real opportunity. Even though when you're not addressing those issues, it's good to think about people, even people who might on paper seem very familiar, people of the same ethnicity, of the same gender, of the same age, from the same part of the world, seem to be very similar, and yet they might be motivated by very different things. One person might be motivated very much by money. Another person might be motivated very much by praise. A third person might be motivated by getting particular job assignments. And so considering what motivates Sally versus Bob versus Larry versus Mary is important. And it's good to get feedback from your employees. Ask them, what motivates you? And also ask them, well, how can I manage you better? How can I be better at my job? Let's talk a little bit about ethics. This is the definition that our textbook has for ethics. Choices of proper conduct made by an individual in his or her relationships with others. So we're seeing that this is about some standard of proper conduct. When we're talking about ethics, we're usually not talking about a statute. We're not saying that a law says you've got to do X. Obviously, if we have that situation, it's a pretty easy call because we know we need to do X. But many times this is a gray area. Either the law is silent, or maybe the law isn't as precise as we might like. And so we're in that gray area. It's not 100% clear what we have to do. So we need to make decisions about what is our best choice. So I thought a helpful way of approaching this issue would be to consider an example from the textbook. I'm just going to read this, and we're going to analyze this using a paradigm that the textbook suggests. So assume that you're a food and beverage director of a large hotel. You are planning for your New Year's Eve gala and require a large quantity of wine and champagne. After all, it's New Year's, right? You conduct a competitive bidding process with the purveyors in your area, and based upon quality and price, you place a very large order in excess of $20,000 with a single purveyor. Sounds like you're doing a great job. You found the right person to fulfill your order. Sounds like you're doing great. A week later, you receive a case of very expensive champagne delivered to your home with a nice note from the purveyor's representative stating how much they appreciate the order. They're really looking forward to doing business with you in the years ahead. What do you do with the champagne? Um, and I'm sure you can immediately see the issue. You were doing this for your employer. You were doing this in your role as food and beverage director. And now you're getting a goodie, a kickback, so to speak, of this very expensive champagne to your home. And the idea might be that while you chose this purveyor this time because maybe he offered the best services at the best price, maybe next time you might think to yourself, well, he didn't come in with the best price or the best services, but he sure gave me some nice champagne. And so you might be tempted next time to give the contract to this purveyor, even if he doesn't come in best, because you feel like you owe him, or maybe you feel like, I'm going to get some free champagne out of this. And so that's where the ethical issue arises. So now we're going to look at the 7 questions as we consider this. Is it legal? Is it legal for you to keep the champagne? It probably isn't. That probably counts as a bribe. And there are probably a statute. And if there isn't a statute, there's going to be case law on that. But even if there isn't a law that prohibits it, almost certainly your company, if it's very large at all, will have some kind of policy that prohibits you from accepting a gift like that. And you can see the way the scenario is written, it said a very expensive champagne. You know, if it were a $5 Starbucks gift card, you know, maybe that's such a trivial value that it might not fall in this category. But I'm assuming if we're talking about a very expensive bottle of champagne, we're probably over $50. Oftentimes the standard that is used in these cases is $25. And so, and that varies from employer to employer. Many employers have zero tolerance even for the $5 Starbucks card. But certainly when you're above $25, you are very likely to run afoul of a company policy and quite possibly of the law. The next question is, does it hurt anybody for you to keep the champagne? I mean, in some sense it doesn't, because you already made the choice not knowing you were going to get the wine, the champagne. But if it affects the decision you make next time, that you choose this purveyor despite the fact that he doesn't have the best prices next time around, then you've hurt your employer. You've hurt the stockholders of that particular employer. And let's say that you were to take that expensive bottle of champagne and give it to the bartender at your bar and say, hey, why don't you see if you can sell this? Maybe with the markup that the hotel would do, maybe the hotel could get $200 for that bottle of champagne. Well, in that sense, the hotel then is out $200 that it could have had. So you could argue that the hotel is harmed. The owners of the hotel are harmed by you keeping that bottle. Is it fair? Is it fair for you to be able to keep that bottle of champagne wherein the other people who are involved in this project don't get it? Maybe you have an assistant. Is he getting a bottle of champagne? Probably not. How about your boss? Did she get a bottle of champagne? Probably not. How about all the bartenders and the shareholders? How about the customers who are coming? Are they getting free bottles of champagne? Probably not. So you definitely have a question about, are all the stakeholders, and we say stakeholders, we're talking typically about the company, the workers, and the customers. Next question to consider is, am I being honest? Am I telling everybody, yeah, I just got a $100 bottle of champagne dropped off at my house? My guess is you aren't saying that because you know, wait a second, I'm not really supposed to get this. You know that your boss isn't going to be happy if he knows that you have accepted this. And so in that situation, if you have an inclination to keep it a secret, you probably ought to trust that to let you know that this is not something you ought to be engaged in. Would I care if it happened to me? Do a little bit of role reversal. Think to yourself, well, what if I were my boss? How would I feel about one of my subordinates accepting the bottle of champagne? Or how would I feel if I were a shareholder in this company and I would know that the person who chose the contractor got something free? Would I be willing to publicize my action? Would I be willing for it to be in the company newsletter? If not, probably shouldn't do it. And then you can universalize the problem. What if everybody did this? What if everybody on the planet, whenever they signed a contract, was entitled to expect that they were going to get that free bottle of champagne? There are countries in the world in which this type of behavior, this kind of gratuity or something along those lines is expected. And it raises real problems in society managing through those issues to make sure that the right things are being purchased instead of just the ones that the supplier who provided the nicest bling to the contractor. And so if you think about it in the larger sense of what if everybody did it, you'd probably conclude that that wouldn't be an improvement to how we handle these transactions. So probably what you ought to do if you get that lovely bottle of champagne is alert your manager to it, let him or her know, and then return the bottle to the purveyor. Say, thank you very much, lovely gesture. Unfortunately, I'm not able to accept this very kind gift, and be transparent in those ways. I hope that this presentation has been interesting and helpful for you. Of course, as always, if you have questions about the material that we've covered, feel free to email me. And also consider stopping by my office hours if you'd like to discuss this material in more detail. My office hours are included in the syllabus. I'm just going to, because this is our first lecture, just do a little brief glance at our module for this particular chapter. And you can see, again, we're going to have something above Chapter 1 PowerPoint. We'll have the lecture up here. Then we'll have a discussion board. And we have two for this particular chapter. Most of our chapters will just have one discussion board. It'll be a substantive one. But because this is our first, we also have a little bit of an introductory one. For each discussion board, you're going to make 2 posts. You're going to make a substantive post, and that's the most important one, where you're going to respond to the question. And in this case, you'll watch, I think, either read a video or watch a video link to find out more about the topic, and then you're going to respond what you think about it. Now, this isn't just an opportunity for you to give your thoughts from a personal perspective. What I want to see is that you're tying this topic to what we've talked about in this chapter, or maybe perhaps to other current events. So don't just say, oh, I think that's a terrible thing, or I think that's an awesome thing, or whatever your reaction to the particular story is, but then raise themes from the textbook. This is interesting, and it ties to the idea of it's important to motivate your employees, or it ties to the idea of the common law tradition, or whatever that connection is. So be looking for ways of connecting the discussion board topic to the chapter that we've just read about. In addition to your substantive post, you'll also need to make a reply post. You'll need to respond to at least one of your classmates' response. And so you'll want to be sure to do that. And don't just say, I disagree, or I agree, but say a little bit more about that than that. Your substantive post needs to be at least 100 words long, and you need to list the number of words at the end. And your reply post needs to be at least 50 words long. You'll need to have your discussion board posts be in complete sentences with appropriate punctuation. A good point to keep in mind when you're writing these is that, especially if grammar isn't your thing, is to keep your sentences relatively short. It's harder to have grammatical mistakes when you have short sentences. So if you are finding your sentences are getting a little bit long, figure out where to put your periods and break it up, and you'll be less likely to lose points because of grammar issues. So that is our discussion board. Let's go back to our the modules. Then we will also have an assignment. Let me just pull up the assignment for this one. This one will be researching the smoking ordinance for Frisco. And what you'll want to do is you'll want to locate the smoking ordinance in Frisco. You can do that by using a good search engine. And you'll cut and paste the ordinance into your assignment submission. And then you'll want to answer these 3 questions. And you'll want to have the number so I can quickly figure out what your answers are to these items. Again, your response should be in complete, grammatically correct sentences, and your entire response should be 100 words long. You don't need 100 words for question number 1, 100 words for question number 2, and 100 words for question number 3. Your total number of words needs to be at least 100 words long. In most cases, you'll probably find that you need more than 100 words, but you might be especially good at cutting to the chase, so to speak, and so you might be able to do 100 words. If you're finding that you're less than 100 words, it probably means one of two things. You're not writing incomplete sentences, or you're not giving a complete answer. So what you don't want to do, let's look at this first question. Does Frisco permit smoking in restaurants or bars? The first thing that you need to do is you need to rewrite this question as a statement, because I should not have to see this question before as I'm reading your response. I ought to be able to tell what the question is just by your response. So I might say, let's say that Frisco does permit smoking in restaurants and bars. So I would say, instead of just repeating the question, I would say, Frisco does permit smoking in restaurants, but not bars, period. And then explain what those circumstances are. Then we have the next question. How does Frisco address e-cigarettes? And I might say, Frisco permits e-cigarettes in these locations, but prohibits e-cigarettes in these locations. And so you'll want to phrase your answer so that it lets the reader know what the question was without actually directly stating the question. In most cases, your last question for the assignment will be one in which you express your own opinion. Obviously, only you know what your opinion is. I don't have a dog in that fight. You can agree with the policy or disagree with the policy as you see appropriate. What I'm most interested in is the reason why. So think it through. And it shouldn't, let's say that Frisco has a particularly strict anti-smoking policy. Well, you might say, I disagree with the policy. Your why shouldn't be because I'm a smoker. You ought to present a reason that you think it's bad for the hospitality industry, or bad for patrons, or bad for the city of Frisco. Present an argument. Or maybe think it's a good thing. Then you present that argument. And as always, remember that I do not accept late homework submissions. We'll have a lot over the course of the semester, 15 in fact. So it might happen that you miss one, or possibly even two. Not a tragedy. Please don't worry excessively if you miss a homework. Just be sure not to miss many. Also remember that you can submit homeworks early. So let's say we're down here in week 5, and the week of October 8 is just crazy for you. You've just been super busy. Well, if you know about it ahead of time, you can go ahead and do this assignment back when we're doing Module 4. You can do both assignments at this time. So working ahead can be a smart strategy to managing your workload. At this point, we're done with the lecture. Thank you so much for your attention. As always, reach out to me if I can add benefit, add value to your learning experience. Thanks so much for your attention. Have a wonderful day.